Thank you for joining us in the English portion of our radio program, Para Ser Legal to Be Legal. Today we got How Much Will My Green Card Cost and How Long Will It Take?
Calificas para ser legal, quieres saber, solo llama al abogado Andres Mejer.
So, the question of the day, I can't tell you how often I get this. How much will my green card cost and how long will it take? The cost of immigration services really varies from person to person. At Andres Mejer Law, we charge by process. So someone who's applying for a green card in the U.S. might pay a very different price than someone who has to leave the U.S. and return through consular process and apply for a waiver. But both of them are filing for a green card. The green card process includes anything from 2 to 6 steps. That's why the price varies so much. Each step can be from $3,000 to $6,000 each. Now, the first thing we do in almost every case, we do a thorough background search for each person applying for their green card. It typically takes 1 to 4 months to get the necessary documents, and we charge $1,000 per person. What does this include? We order documents from immigration agencies through the FOIA process. It's 7 different agencies. We're looking for prior border contacts, deportations, prior petitions, or mistakes in immigration's documents, which does happen. We also do an FBI and motor vehicle search, and then we request copies of all dispositions for each police contact. Again, we want to make sure that if you were charged with something, it was dismissed, it was resolved, it isn't something that's going to disqualify you. So first, we look at your background. We say, hey, is there anything that makes you inadmissible, like crimes? If there are crimes, we fixed it. So now we fixed your prior crimes or realize that they're not going to affect you because you've never been arrested. We then evaluate, okay, are you getting your green card in the U.S.? Are you getting your green card outside the United States through the consular process? If you didn't enter legally and you have a close family member in the U.S. military, we likely will file for parole in place. This gets you legal entry and it gets you work authorization. Now, parole in place, we typically charge from between $3,000 to $4,500. It could take 3 to 8 months. Sometimes there's an interview. That's why it's $4,500. If there's an interview. If you don't qualify for parole in place or you don't need it because you entered legally, we file what's called a petition for alien relative. It's known as Form I-130. The I-130 lately has been taking 8 to 12 months to get approved. Now here again, the price varies. It's easier to document that your sibling is your sibling than, or that your parent is your parent or your child is your child. It's a lot easier to prove those blood ties than it is to prove that your marriage is, not that it's not legal, that it's bona fide for immigration purposes. If I go in front of a judge and I'm married, that's a legal marriage. But that doesn't mean I didn't pay her because I'm the immigrant and she's the U.S. citizen to file for me. So that's why immigration requires to show that it's bona fide. So what relationship, who's filing for you, makes it easier or harder, and how many people are getting a benefit. For example, let's say your U.S. citizen spouse is applying for you and your 2 minor children from a prior relationship. So that would be 3 I-130s, 3 filing fees, 3 legal fees. Now, we don't charge the same. We charge adults, and then for children, we charge a nominal amount. But again, who's receiving the benefit? How are they receiving the benefit? That matters to how we calculate price. Now, what happens if when we ordered your background search, we discovered you have an order of removal? Now we have to deal with it. Or you're in removal proceedings. We need to deal with it because you may not be able to get a green card if you're in removal, and you're definitely not getting a green card if you have an order of removal unless we do something about it. But either way, if you're filing an I-130 and you have an order of removal, or you're in removal proceedings, you almost certainly, and I'm saying 99.5% under Trump, you're having an I-130 interview. The standard is higher because you already are either in removal or you have an order of removal. So you have a very strong chance of being detained. So we have to be prepared to request your release. Now, we typically charge $1,500 to attend an interview or a court appearance. Either way, it's a half day's work. It's not just the appearance. It's also not just the travel there and back and the time there, but it's also the preparation for the interview. Now, once the I-130 is approved, if there's an order of removal, we have a decision to make. We can either file a waiver to ask that the order of removal be forgiven, or we file a motion to reopen. Motion to reopen is like a post-conviction relief motion. We're going back to the court that ordered you deported, and we're asking them to eliminate the order of removal. But what happens now, that puts you back in removal proceedings. So in the past, it was easy to get removal proceedings closed. Now it's not so easy. So we more often are filing I-212 waivers. Now, if we file an I-212 waiver, again, depending on the complexity, it could be $3,000 to $6,000, and it could take 4 to 6 months. If you don't want to file an I-12, then we have to file a motion to reopen. That's also could be $3,000 to $6,000, depending on the complexity. But understand, if the motion is granted, now we have to represent you in court. So now we have to go to court, $1,500 for each appearance, and if it comes to a trial in front of a judge, it's a $5,000 fee if it comes to that. A motion to reopen has been taking 6 to 9 months, but it really depends on what immigration court ordered your removal. Typically, the busier the court, the longer it takes. Once the case is reopened, we may get your case remanded to USCIS to adjudicate, in which case there's an interview fee of $1,500 instead of a trial of $5,000. Even if you had the I-130 interview and it was approved, you'll still have another one when you're now officially changing your green card. Court will take 2 to 5 years, and it could take many court appearances, 2 to 5, until we get the final trial date. We have some clients that have been going on for 8, 9 years. So the next stage, let me put it in context. We ordered your background. We got rid of any criminal conduct. We filed the I-130. The I-130 was approved. Now we either filed a waiver to overcome an order of removal, or we filed a motion to reopen, or you're not in removal. So now we're at the part where you change your status from whatever it is, an unlawful immigrant or a visa overstay, or a student visa, to a lawful permanent resident or a green card holder. So if you're changing your status in the United States, that's Form I-485. If you don't qualify to adjust in the United States, or you don't want to, you will need Form DS-260. It's a Department of State form, and you're going to be interviewed outside the United States. Either one of them are between $3,000 to $6,000, again, depending on the circumstances. Now, if you entered legally to the U.S., or you got parole in place, or you qualify for 245I, what's the Life Act? What's that? That just means someone filed for you before April 30, 2001, and that petition was approvable. So basically, either you entered legally, you got parole in place, or you qualify for the Life Act. You can usually file the Form I-45 at the same time as the I-130. That means you're going to get work authorization if you don't have it, a social security number if you don't have it, well before you become a green card holder. Now, we typically charge $1,000 to also file for 245I. The background search, which we start with initially, typically gives us all the documents that we need to prove 245I eligibility. So it could be that your father or your brother filed for you back then, but the visa wasn't available, or an employer filed for you, but for whatever reason it wasn't ultimately approved. Maybe by the time it happened, you're no longer working for that company because 8 years passed. Now, filing the I-45 in any of those circumstances, parole in place, legal entry, or 245I, gets you work authorization and a social security if you don't already have it before getting your green card. You will have an interview at a USCIS office, and the officer, now they used to decide on the spot, today not so often. They're supposed to decide within 120 days of your interview. At the interview, the officer can request more documents, indicate you need a waiver for something in your past. Now, generally we find that, but it doesn't always depend on us. Sometimes the officer, even mistakenly so, thinks you need a waiver that we don't agree with, but then you have a choice to make to either file for the waiver or appeal or fight the officer's intransigence. Wilson asks, how old does your child have to be to file I-134 if you enter without permission and your child was born here and is over the age of 18? In order for a child to file for you, it needs to be 21 or over, Wilson. Now, just because you have a child who's 21 doesn't mean they can file the I-130 for you. So, because did you enter the U.S. or legally, or parole in place because they're in the military, or 245I eligibility? If you don't have any of that, if you can't get parole in place, you don't qualify for 245I, and you didn't enter legally, you can't adjust in the United States. You're going to need to leave, and in order to leave the U.S., you're going to need a waiver. That's exactly what we're going to talk about now. If you didn't enter legally and don't qualify for 245I or parole in place, you're going to have to consular process. However, the moment you step outside of the U.S., so this goes directly to your question, Wilson, the moment you step outside the United States, you won't be able to come back for 3 or 10 years unless you apply and are approved for a waiver. So what are we talking about? If you're in the U.S. without permission, that means you entered legally but overstayed, or you didn't enter legally, and you're here more than 6 months, more than 180 days, but less than a year, you can't come back for 3 years. If you're in the U.S. without permission for more than a year and you leave, you can't come back for 10 years unless you apply and receive a waiver. It's called the Provisional Unlawful Presence waiver, or Form I-601A. The problem, Wilson, you may have, and I don't know your facts, I'm just based on the question you have, if your son is not a qualifying relative for a waiver, you need spouse or parent who's a U.S. citizen or green card holder. So I hope for your sake, Wilson, that either one of your kids goes in the military, you entered legally, or eligible for 245I. Now, back to the Provisional Unlawful Presence waiver. If you have more than one thing that makes you ineligible for your green card, you may need additional waivers, but then you're not going to be able to file for the Provisional Unlawful Presence waiver. So if you have multiple problems, you're going to have to leave the U.S. and then file for those waivers once you're outside of the U.S., which means you're going to be out for 6 months to a year while you're waiting for those waivers. My pleasure, Wilson. If you only have that one thing that makes you ineligible, the manner of how you entered, you can file for your waiver inside the United States before you leave. It takes them 6 to 9 months to approve, and you're going to be outside of the U.S. only for 2 or 4 weeks. So it's a pretty darn good deal. Now, how long is it going to take you to get your green card? So look, you see all the steps that we talked about. Review of your background, any criminal conduct, file the I-130, any order of removal, do we have to reopen, do we have to file a waiver, are we doing parole in place, 245I, can you file inside the United States, can you file outside the United States, do you need waivers on the back end? So there's a lot that goes into it. But in general, green card inside the United States is taking 9 to 18 months. And it really depends on whether you need to have one or more than one interview. If you are consular processing outside the United States, it's generally taking 18 to 24 months. So as you can see, this gets really complicated really fast. It's for that reason that when you call and you speak to one of my assistants, no matter how experienced they are, they can't give you a price on the phone. The green card can cost from $6,000 to over $30,000. The more we have to do, the more complicated the case, the higher the cost. But you don't need to worry because we do offer payment plans. We'll work with you. We'll meet you where you're at. We also offer discounts for those who pay in full. So the more money you bring with you to the consult, the higher the possibility of getting a larger discount on your immigration case. Now, we also give your case the priority that you do. So the sooner that you pay in full, the sooner that it gets filed. Now, we typically need several weeks from when we have all the documents, once we have the answers to all our questions, so we fill out all the petitions, and we have your payment in full. We start working the moment you hire us, but we don't file it until we're paid in full. How long does that take? Well, it depends. If it takes you 3 months to pay in full, it might take us 4 months to file. We believe that is a fair way to help and to represent others. So look, I hope this was helpful. We talked about how much does my green card cost, and we really talked about what are the different steps that you need to be for this is a family-based petition. Is it my spouse who's filing for me? Is it my parent who's filing for me? Wilson says, does DACA help you a little more? Here's how DACA could be helpful. Let's say I entered without permission. I am a dreamer. I just came here earlier. I applied for DACA. I got DACA. Now, I could have applied for advanced parole. And please, Wilson, don't apologize for answering the question. I love questions. We invite questions. So if I could have filed for advanced parole, which gives me permission to leave the U.S. and come back. Now I have legal status. If now me who has DACA marries Kim, my wife who's a U.S. citizen, she files for me, I have legal entry. Within a year or a year and a half, I will have my green card. So DACA by itself is not a path for legal status. It's not a path to get the green card. but it is protection from deportation. Now the question is, what happens if the Supreme Court, we expect a decision any day now on DACA, what happens if they eliminate it? Now we have a real problem, because we have 700,000 and change immigrants that have DACA, and now that status is revoked. What's going to happen? So stay tuned. Let's hope it doesn't happen. But if it does, we'll have a game plan, and it'll start with an evaluation. What does the individual stand for? Because everybody who loses DACA is going to be put in removal proceedings. So who's filing for you? Can you adjust in the U.S. or outside of the U.S.? Are there things that disqualify you, like criminal conduct? Do we have to file a post-conviction relief motion? We have to order that information to see how it affects you. Do you have an order of removal? Are we going to file a waiver to overcome it? Or are we going to file a motion to reopen and defend you in court? Are we going to have to go with you to multiple interviews with USCIS while you're in removal proceedings? If maybe you need a waiver for prior fraudulent acts, or the government says it's fraud. It may or may not be. Or criminal activity that doesn't rise to the level that completely disqualifies you. So every case is different. In the main, the most common waiver we do is the Provisional Unlawful Presence waiver. After that, it's I would say a fraud waiver. When someone entered the United States but entered with a fake passport, or entered with a passport not theirs, we can prove how they entered, but it's still a legal entry. They can still adjust in the United States, but the reality is they did lie, so they have to apply for a waiver for that. That's probably the second most common waiver that we have. Third would be criminal conduct. We try not to do it. We really prefer post-conviction relief motion. I'd much rather show the officer or the court that the charge was overturned than having to ask the government to forgive me for something. I don't want to be in that position. I'd rather say, hey, I was dismissed. It was a constitutional mistake. I had a bad attorney, or I made a bad decision. But here we go. It was ultimately dismissed. I'd much rather be in that position. Thank you for your time. My name is Andres Mejer, and until next week.